Oh, good to have you back. That's a live shot from outside the Latah County Courthouse. Joining us now live. I want to get right to him. You know him because his name is quite literally the lawyer you know. Peter Tragos is back with us here on stream. Peter, you and I did a lot of conversation about the Idaho murders at the University of Idaho. We did a lot of conversation about Bryan Kohberger and the legal situation surrounding him. Let's just dive right in. We're going to start to take your questions, folks, out of the YouTube, Twitter, Facebook Live comment sections, TikTok as well. Hashtag KJB, hashtag lawyer you know, as we let those comments come in with those hashtags so that we can animate them on screen. Peter, your perspective as far as what has unfolded so far today. Bryan Kohberger being arraigned, standing silent, the judge entering a not guilty plea, and now we have a trial date for October 2nd.
Yeah, I mean, there's a lot that's happened today to unpack already. Just starting with the arraignment, the choice to stand silent. It is a choice. It is not the norm. You would think if you want to claim you are innocent that you would say, I am not guilty of these charges. We've heard that in other cases. Specifically, Murdaugh pounded the table, continued to throughout the entirety of his trial, even after he lost. Many people do it even after they lost. And right now, Bryan Kohberger has decided not to do it when it's the most public time to say that he is not guilty. It could mean absolutely nothing. Or it could mean maybe we are going to work towards a plea deal or something is happening behind the scenes that we just don't know about yet.
Peter, I just want to bring up the very first comment that we have from our audience. And it's from Lissy, who says that we're neutral and unbiased as far as covering this case. We really appreciate a lot of the appreciation that we get on YouTube. Peter and I have seen a lot of the comments that have come in over the last 5 months. We have not talked about this case, Peter, since January, but a lot of people do, of course, appreciate just some of the interaction that you and I have, and then, of course, the interaction that we have with our audience. So let's start to get into some of the hashtag KJB, hashtag lawyer you know, questions and comments, and it starts here from SH. Hashtag lawyer you know. When will we know if the prosecution is going for the death penalty?
So I think today was so important as the arraignment and his not guilty plea because it started the clock on a couple things. It starts the clock on the state's ability to file a notice of intent to seek the death penalty in Idaho. They have 60 days from today, and it triggered his speedy trial. 6 months from today, they have to set his trial, which is why the trial date, I think, is October 2nd or sometime in early October, which is near the end of the speedy trial period, which I think is also interesting that the defense chose to kind of kick it out as much as they could without waiving speedy trial, which I think is the best case scenario here and exactly what I would do if I was the defense attorney on this case. It gives yourself as much time as possible because they can still waive it anytime they want. They can show up on October 7th, ask for a continuance, waive speedy trial, and then kick it down the road. Or if they want to keep the pressure on, they can push the state to get that case tried on October 2nd.
You know me, I like to put you on the spot, Peter, with percentage chances. I've done it a lot of times on our previous live streams together. Percentage chances that this actually begins in early October.
5%.
Wow, that low.
Yeah, I think they do not seem to be pushing the envelope on this case. They waived his speedy preliminary hearing. I think they've been working in the background with the state, working on discovery issues. They wanted to delay this gag order hearing. They have to prepare. They have to get things ready. That's another thing that's going to take another month of work that they're not working on the case because they're working on the gag order. They push it till the very end of the speedy trial period. So anything happens and they have to extend it basically at all, the judge is going to ask, are you agreeing to waive your speedy trial right? Because if they file motions saying the state refuses to give us this stuff, or they file motions doing anything to delay the case, they're going to have to waive their speedy trial. And I think that that's probably the likely scenario at the end of the day, but things could change over the next 6 months.
We will be paying very close attention. A lot more to go over with Peter Tragos. For those of you refinding the live stream, perhaps you saw the arraignment earlier here in the center of your screen. Maybe you're coming back to YouTube Live, Facebook Live, TikTok Live, or WFLA.com. We're on here live with Peter Tragos, the lawyer you know, who has done a lot of different live streams about Bryan Kohberger and, of course, the University of Idaho murders. And I'm sure that he will have live streams in the hours, days ahead as well. Let's go to this one from Brianna. Hashtag lawyer you know. Do you think Bryan's silence is likely at the advice of his lawyer for the sake of the court or excuse me, for the sake of the court of public opinion.
Yeah, I think that's a really good guess, which is all we're doing at this point. But by doing anything outside the norm, they know people are going to talk about it. Okay. It's not a surprise because he could have just said not guilty. That's what everybody was expecting. People that think he's guilty in the media or in the court of public opinion are still going to think he's guilty, even if he says not guilty. People that think there's something fishy going on, he probably didn't do it, they're still going to think that if he says not guilty. It wasn't really going to change anybody's perception if he would have just said not guilty. That's what everybody expected. But doing something different is interesting. My guess is it could have been on the advice of counsel because we know the gag order arguments, we know the media attention, we know the public concern and interest in this case is high. So maybe she just said, they're going to pick apart every word you say, the way you say not guilty. If it's too soft, if it's too strong, they're going to pick you apart for that. So just say nothing. Effectually, legally speaking, it's still a not guilty plea, and let's just keep the case rolling.
Very interesting. And he did voice words today in responding to the judge. So it's not as if he didn't want to speak because he was listening for the prompts of when to speak, and then he chose to speak when Judge asked him various questions over the course of the arraignment. However, that moment he chose to stand silence as far as the moment when it was time for him to enter a plea. I want to go to Team Brittany here, who's one of our great moderators on the WFLA YouTube page. Even our moderators can ask questions. Of course, they're very much part of the process here, what we do interactively on WFLA Now, #LawyerYouKnow. If you have a moment, could you explain to the chat what you spoke about the other day as to wording, may and could versus does, as it relates to a person having exculpatory evidence?
Okay, so there's a lot to unpack here, and depending on whether we're talking about the grand jury or anywhere throughout the process, but during the discovery questions and some statements made by the defense, you will hear them say there may be exculpatory evidence here that the state hasn't turned over. That does not mean the state is hiding exculpatory evidence. The state has already once in this case said that they are turning something over because they want to make sure they're within the Brady. They don't make a Brady violation, which would be a discovery violation, withholding exculpatory evidence. So the state knows if something like that comes up, they have to provide it to the defense. So it doesn't seem like they're hiding anything, but in order to highlight the importance of certain documents or certain videos or certain audio recordings, the defense will sometimes say, Judge, there could be something exculpatory in here. We need the state to produce it, and we need them to produce specifically this so that we can listen, watch, or read to see if there is exculpatory evidence there.
I want to ask you about what we were talking about earlier on stream. We'll look for some more #HeyJB, #the lawyer you know or lawyer you know. I'll look for LYK too, just because it's the cool thing to do. The cool kids with LYK in our comment section, man. 51 terabytes. Peter, if you were my attorney and you were defending me and 51 terabytes of evidence fell into your lap, your first gut reaction is what?
So you have a duty to go through it and see what's there. And you can't rely on whatever somebody else titles a document or a clip, right? You've got to actually sift through all of that, which is why I think some of the motions to compel could be to specify or answer the question specifically. We've had cases that are incredibly document intensive, construction litigation or wrongful death cases with tons of medical records or medical bills. And certain discovery questions can say, do you have this? And I can't provide 100,000 pages and say the answer is in there. I have to actually provide the document or the answer that they are requesting. So it's one thing for the state to say we turned over all the evidence. It's another thing for them to specifically answer a well-tailored request for production or an interrogatory request from the defense. So that could be some of what they're arguing about, or the defense could have gone through everything and said, it's not here and we know you have it.
So is it gamesmanship between the two sides? Is any of that going on?
So we know that there are timelines that you have to produce this stuff, right? 30 days to produce 51 terabytes of documents and to go through all of those. Maybe the state's saying it was impossible. We don't have the manpower or woman power to go through all of this. So here's everything we have. We're not hiding anything from you, but we can't go through it and specifically pull out documents within 30 days. So we want to make sure we're within the rules. We're discovering this to you. We're producing it. Here it is. You can use whatever it is you find in there. We're an open book right now with you. It might not be gamesmanship at all. It might just be a timing and a manpower issue.
We haven't brought really this up on this live stream yet, but I know that I was following you a little bit on Instagram. You know, we follow each other. We're pals like that.
Oh, yeah.
Tanya says, #lawyer, what did you think of Dateline? The timing it came out. And in Tanya's opinion, all the speculation, no facts. I'll get into this here a little bit too, but Peter, why don't you go first?
Sure. And I mean, I'm sure there were facts in there, but there was some speculation as well. It's TV. That's kind of part of what you get when Dateline runs an episode like that. They want to make it interesting. They want to make it captivating. And this kind of also relates back to the very first comment about how we try to bring the facts and not be biased or point one way or the other and just kind of tell you what's going on and explain the process. And I think that as we look at this, as we see the Dateline show, and then as we hear from the judge today at the hearing you just streamed here on WFLA, the judge said rights, and there's irreparable harm going both ways. Rights are being violated. The Sixth Amendment right to the Constitution that the defendant has in this case, irreparable harm could be caused by the media, and I think he may have even said is potentially being caused at this point. And he's thinking about, I believe, Dateline NBC, documentaries, news shows that are going on and taking speculation, calling it fact, condemning Bryan Kohberger, convicting him in the court of public opinion when he hasn't had his day in court yet. And regardless of what you think about his guilt or innocence, we have to understand how the process works and how we go through it, because the judge is going to look at that. He's going to look at this show, JB. He's going to look at mainstream media and say, how are they talking about this? If they're discussing it as they can't wait to hang this guy on the cross, he's not going to like that, and the gag order is going to be restricted. But if they're talking about it like you do, JB, in a way where this is what happens, what does it mean? What's the timeline? What are we looking at? What could standing silent mean? Those are the good questions. Those are, I think, what the judge would absolutely allow the media to talk about and would actually come forth with a less restrictive gag order if that was how most people are talking about it. I just don't think it is.
I can't help but wonder if the gag order is making the gag order being as restrictive as it is, and reporters having to go through back channels for information, if that is contributing to the overall problem here. It almost seems like a cycle where we're all caught in this this laundry machine cycle of information that is going around, and it's also, is it compromising the process? That's something, of course, that a judge has to take into consideration when they look at how the public is falling in. And also, too, we've talked about this so many times, how you go about jury selection in a case that is so mainstream. When everybody knows about it and everyone has formulated an opinion, that can make it very, very difficult to find an impartial jury.
Protecting the rights of the people in the courtroom comes first for the judge, and protecting that process. Then protecting the public and the First Amendment rights and what we all as the public have a right to is secondary. That's why it's a balancing act. Just because we want to know what's going on doesn't mean we're going to violate the rights of the criminal defendant or even the state if it's affecting the state. I absolutely agree with you. And it's not just in this aspect of life, but when you do restrict from legitimate information, people are going to go looking and searching and maybe reaching for less legitimate information. That absolutely can be a side effect. So how do you balance that? I think there's a way to write a gag order in effect that will allow things to be more open to the media while still not allowing interviews and, potential leaks from law enforcement or things that can be used or weaponized in the media to condemn people before they have their day in court or condemn some of the victims in the case. We've seen that going after victims. Why didn't they do this? That's what we have to be careful of, because everybody in the process needs to be protected.
Let's go to this question from Amber. Hashtags for us both. Now that he has, let's clarify this, because she's saying now that he has chosen a speedy trial, has he technically selected his right to a speedy trial? I mean, he hasn't chosen that, or has he? Would you verbalize it that way?
So I would say that he has not waived his right to a speedy trial.
Right.
And by not waiving your right to a speedy trial, you are saying that I get a trial in 6 months. That's how it works. Right. And if the state does things to delay the case, then they could say, we're demanding a speedy trial, and they're violating that right. But if the defense today would have agreed to a trial date next May, they would have in essence waived their right to a speedy trial and agreed to a trial date outside of the 6 months. Now, there are times where you can agree to a trial date next May and then later demand your right to a speedy trial and push the process quicker. There are pieces in place that have a shortened timeline that you can still keep your speedy trial rights even though you've agreed to a later trial date. But many times, if you filed a motion to continue or agreed to continue a case, there are things that can happen that are effectual waivers throughout the process, and they absolutely did not do that today.
And again, I want to reiterate, as Peter noted earlier, and I want to make sure, because there was some confusion in the comment section. You are saying that there is a 5% chance, in your expert opinion, a 5% chance that this trial begins in early October, right? And a 95% chance it gets delayed. Is that correct?
Yeah, and again, it's a pure guess. Okay, so I could say in your expert opinion, but I have no crystal ball on when this case is going to go to trial. And as you and I have talked about, I think we talked about the Petito civil case. We talked about when's that going to happen. I told you a 0% chance it happens whenever the first trial date was for that.
You're right.
So and that one I felt much more confident. The reason I put 5% here is certain times in these criminal cases, the defense will think it's actually better to get this thing rolling, not let it fester, not let the public just continue to rise up. Again, we saw it in the Murdaugh case. We actually saw, in my opinion, even though Alec Murdaugh lost, there was some benefit to the defense that they did push it to a speedy trial because it made the investigation look that much worse. And in this case, by waiving a speedy preliminary hearing, the defense was able to do some discovery. So in a normal case, if they would have arraigned him immediately and done the grand jury indictment immediately, they would have had a lot less time to prepare than they've already had to prepare in this case. So that's why I put it about 5%, because I don't expect it to happen, but I don't put it at 0. That's for sure.
There is a strategy here, no doubt, regarding the timeliness of the trial and how the chips fall, if you will, is going to be fascinating, both from a prosecution standpoint and from a defense standpoint. But I want to really quickly, we have other comments in the queue, and we're going to be getting to Bryan Entin here shortly. So I want to try to get as many as we can, because I know that Peter doesn't have all day to be able to talk with us. As far as the trial being pushed out a couple of years from now, 2024, 2025, real quick.
So one of the hard things is once you start to continue it, once you waive your right to a speedy trial, then sometimes it can snowball and you can't get it to go fast enough. So that's why it lasts years. I wouldn't expect this one to last 4 or 5 years, though. No.
We know this name. Azam says #HeyJB lawyer, and yeah, the golf emoji, which you see in Peter's chat all the time. Is the standing silent common during this process?
It is the least common plea, or if you're going to call it that, it's the least common approach. Usually you just plead guilty or you plead not guilty. But it does happen. It's not, unfounded or never happened before or so shocking. And that's why there is a place in the law that it just basically means the same thing as a not guilty plea.
Do you think it is more likely that he chose that for himself, or that it was under the advice of his attorney and Taylor to use that option?
I would guess it's under the advice of counsel, but he does seem to understand the process and probably want to make some decisions for himself and maybe use some quirky legal angles.
Right, because we're talking about somebody who is studying criminology or has studied criminology. So we have to remember Bryan Kohberger's background and how it fits in as far as how he devises his strategy. Not to mention also, he has had 5 months to think about this. I mean, the indictment was sudden and came, just last week. But at the same time, he's had a lot of time on his hand behind bars to think about, the different strategies that he might deploy given the likely outcomes that currently exist legally in this case. Let's go to Atharia. It's a pretty name. #lawyer, What could be exculpatory evidence except a solid alibi in this case, considering that they have his DNA at the scene of the crime? It's a very interesting question.
I mean, what could be exculpatory evidence is a pretty long answer. A ton of stuff could be. If one of the statements from one of the witnesses was that he was there, they were friends with him, and that's why he had a reason to be there. His DNA had a reason to be in there. One of the statements that somebody else, that there were multiple people in the house, that the DoorDash person is actually who they saw walk through the house. I mean, there's so much that could be exculpatory that it's hard to just pin down one thing. But it seems like if anything is exculpatory, most of it is pointing towards witness statements or timeline parts that could prove he didn't actually do this, which I don't know. We'll see.
Let's go to some others in our comment section. We only have another couple of minutes. I'm just gonna put up this comment and just say, what are your percentage odds on the change of venue? How about that? Because this question, while it is asked in a hilarious way, what let's just focus on the question itself.
Sure.
The percentage chance of a change of venue.
I would put it at 50-50. We've seen stuff like this already happen in Idaho. We know the media attention on this is going to be next level compared to Lori Vallow, which was the last case that was in Idaho. That was big, that there was a change of venue. So I really put it at 50-50. Most cases are much, much less of a chance of a change of venue. That's actually a really high percentage chance of a change of venue.
That previous comment, by the way, is again proof I don't ignore. I'm always looking for the best comments, regardless. Hey. Yeah, just trying to get the best quality content possible here. Peter knows what I'm talking about. Low Country hashtag Hey Laura, do you think Bryan Kohberger is working on his own defense?
The only thing that would make me say no to this is Ann Taylor has conflicted off other cases kind of in a public way. She seems to be a good public defender, death penalty certified. She seems to be fighting for him. All of those are indications that they're working together. I don't want to say lawyers don't work as hard when a client's a jerk and wants to represent themselves and is demeaning them throughout the whole process. We've seen clients like that. And cases like that in a high profile nature. So right now I would say no, but it's definitely something that we're going to have to follow into the future just with his background.
I'm going to the notepad as we look here. This is a replay, folks, of the gag order feed, as I understand it. And as we look here at John Judge, the judge in this case, I want to bring up this one point. He paused when he was reading the names during the arraignment this morning, Peter, and he paused and he said, sorry, this is hard, as he was going through the names. Some were noting about the pronunciation of some of those names in our comment section, but he seemed to pause a bit and even apologize to the court. Is there anything, we're seeing this judge really for the first time in this case, so what do you make of him and his hearings today, including the arraignment?
Well, just in the very short time I've had an opportunity to observe him, he seems like the type of judge that is going to make a call, is going to say what he thinks. Some judges don't. He is going to tip his hand a little bit, like I think he did to the media, and how he talked to them about their motion and what he found frustrating in it, or that he disagreed with in it, when he said, I don't mean to teach you, but you should know what it means when a higher court has a holding, and that was not it. And you called it a holding in your motion when he talked to the media's lawyer. I think that he is the type of guy that's going to show a little more emotion as a judge than we may be used to in some of these other cases. And I think that was an indication of it when he was reading the names and kind of just understanding the gravity of this situation, which it affects everybody. Anybody that understands what happened, that does not mean he thinks Bryan Kohberger did it. For him to think that what happened here is sad does not mean this is the guy who did it and I'm going to make sure he gets convicted. Not at all. It just means this is a sad situation and everybody understands that.
Mortar says, hey, lawyer, I noticed that when he paused, there was audible crying in the court. I think it might have made the judge emotional. Peter, we got to let you go. We've got Bryan Entin standing by next. Peter, I know you're going to be doing live streams on this. Where can people find you?
So on YouTube, Lawyer You Know is our YouTube channel. If you want to check out any of the videos we've already made or lives that we're going to do, hit the reminder bell, because we kind of do them at random times whenever I can. At Tragos Law on all other social media platforms, Instagram, Twitter, etc. Would love to talk to you guys about the case, and I'm sure I'll be back here to hang out with JB some more.
Yeah, Peter, I always appreciate it, man. I enjoy our live streams together. Thank you so much, and good luck on your lives as well as you continue to cover this case.
Absolutely, and Bryan's awesome, so enjoy him while you have him.
Yeah, we've got 10 minutes with everybody. Bryan Entin. In fact, let's bring in Bryan Entin now, joining us from outside the Latah County Courthouse. Hey there, Bryan. Good to have you back on stream. You were in there. We were following your tweets every step of the way over the course of the arraignment and then the subsequent hearings that took place as well. How you doing today? And what's the latest from Idaho?
Yeah, hey, sorry, I wanted to be able to get live with you before the hearing, but it was so crowded outside. There were so many people lined up, and then it was kind of like a rush to get inside. It's such a small courtroom. I would say only like about 50 seats or so, and there were 25 family members that took up half the courtroom. So I was just so focused on getting in there, I wasn't able to come on with you this morning. But yeah, we're just outside now. Things have sort of settled down. You can imagine it was kind of crazy out here earlier.
You got leave it to Bryan Entin, everybody, to apologize to us for not being on earlier. It's great to have you on now, Bryan. So let's just talk about the case. I mean, everything was very procedural this morning as far as the arraignment, but a lot is being made of his choice to stand silent. We just had Peter Tragos, a legal expert who comes on stream with us quite a bit, and he said that is not something that you see very much as far as that legal option. What has been made of his decision to not verbalize his own not guilty plea?
Yeah, I think it was kind of a striking moment. I think most people expected them to say not guilty. I think there's probably like some procedural reasons, and Idaho law has some strange things that are different from other states. I was actually just before this trying to talk to an Idaho attorney who I talk to a lot, who I haven't been able to get on the phone yet. But I mean, clearly his intention at this point is that, to plead not guilty, that he thinks he's not guilty. I don't think they would have talked about the trial the way they did, going back and forth, picking the date, planning on having a trial at this point. But yeah, I mean, it surprised me. I think most of us expected, to hear the words not guilty out of his mouth, not out of the judge's.
As far as judge, and his pause there in court, you were there. We've been talking about that moment where he had to just he apologized and said that this was hard for him. What was going on during that moment as the victims' names were being read aloud in court in today's arraignment?
Yeah, he definitely messed up some of the victims' names, several of them, and said Kayla instead of Kaylee. And I don't know what was going through his mind. I mean, obviously I was sitting there looking at him, but I don't know if he was emotional or just nervous. I mean, obviously it's a small courtroom. They don't deal with a lot of hearings with, so much media and that kind of a thing. But it definitely frustrated the families. I mean, you could, because it wasn't just one time, and you could kind of see the look on their faces. And then afterwards, I heard several of them saying that they thought that it was disrespectful. But emotions are already just so high, in there. It's so small, JB. I don't think people realize, because you just see that one camera angle, but it's a very, very small courtroom. So where the 25 family members are sitting is very, very close to Kohberger. And I think that everybody is very, very tense, in there.
Yeah, and of course, there also is the element of the gag order as well, and the Gonzalez's family. I mean, they are, of course, frustrated with the gag order. We, of course, read out the statement from the family that you tweeted out. Have you had any additional conversation with them or the families of the other three victims as well in relation to their reaction to seeing Bryan Kohberger in that courtroom today? And now that we have a trial date, even though there's always the chance, and according to Peter Tragos and others, there's a chance that gets delayed, perhaps even into 2024. As we hear from more people, where does this go from here, Bryan?
Well, you bring up the gag order, so they've not made a decision. The Judge John Judge, his last name is Judge. They haven't made a decision on that yet. They sort of pushed it off today, which is frustrating to Kaylee Gonzalez's attorney, because the way it's written now, there's a big question about whether he's even allowed to speak to the media, and that's why he hasn't, because it could be a violation. And really his job is to speak to the media so that the family doesn't have to be the media spokesperson. So he's looking for clarity so that he can start doing that job again. And now he'll have to wait. So that's one component of it. The other component of it is the media coalition, which is sort of headed up by the Associated Press, has filed these complaints saying that the gag order is too strict and there's not enough public information. So the judge also didn't rule on whether he's going to make the gag order more lax. That's all going to come up at the hearing next month. So that's all to be continued. In terms of how the families are doing, I haven't spoken to the Gonzalez's at all, besides a couple quick texts about Olivia, Kaylee's sister's baby, just being really, really cute, because that was just an interesting moment in court that I haven't really seen before, wasn't expecting. Last time I interviewed Kaylee's sister, Olivia, she was pregnant. Well, she's now had the baby, and then she brought the baby to court in this sort of, I don't know what you call those things, like a coddle or whatever you have, like where you have the baby on the front of you. And so, there was sort of like the baby cooing noise throughout court, and you could tell that it was like the baby was really comforting the family. It was just a really kind of interesting, emotional dynamic having the baby there. And I think just added to the sort of just rawness of the whole experience inside that courtroom.
High emotions for sure, especially you could just tell we were listening on live stream, or at least after the delayed feed came out, just how everything in the room felt like it changed when we started to hear Kaylee's name and Xana's name and Ethan's name and Maddie's name. It was just, it was a moment for sure, because it brings everything back, of course, to the 4 victims in this case. Bryan, do you have a free 5 minutes for just some questions before we let you go?
Yeah, sure. Yeah, I think so. Yeah.
Okay.
Yep.
Hashtag, if you need to hop off, you let me know. You know how it works. Hashtag Hey Bryan, hashtag Hey JB. If you use one of those hashtags, we can take it to NewsNation senior national correspondent Bryan Entin. James says hashtag Hey Bryan. And this is for you, as far as your observations. Any surprises for you in court today?
No. I mean, the fact that they set a trial date, I wasn't fully expecting. Of course, like you said, from some of the guests you've had on, that can change, it can be delayed, and who knows what will really happen. But they did seem confident when both sides agreed on the October 2nd date, and I wasn't really expecting that. So that was kind of a surprise. Again, just the eeriness of being in there, honestly. I'm in Florida too most of the time. I'm from Florida like you, JB. I'm used to big courtrooms. There's just something, when you're in a space that small with an accused killer and the families, that's just weird. So that, it didn't surprise me, but was just it's a strange situation. In terms of, a lot of people have been asking me, did Kohberger look different? From the last time I saw him, he looked basically the same to me. Maybe his hair was a little longer. I mean, just a minor thing. And he has some sort of protective vest or something on underneath his jumpsuit, so he did look kind of big. But I think he's very skinny. That's just the vest. But yeah, those were sort of the things that stood out to me.
And also, too, while I have you on stream here, Bryan, was there any video that you and the NewsNation team captured of him leaving the courthouse, or is he still at the courthouse? Has he been transported back to jail?
Well, it's interesting, JB, because, again, I don't think people realize how small this community is. I mean, the courthouse is 2 courtrooms, very, very small. The jail where he stays is under the courtroom.
Okay.
Right in the same little building. There's not a lot of cells down there. So they just bring him up some stairs and he goes to the hearing, and then he goes right back to the basement.
Got it. I didn't know it was that close as far as on the premises. Let's go back to the questions that are coming in from people. Colin wants to know, and we'll go here to this feed. Oh, hold on one more second. There it is. Colin says, hashtag KJB, hashtag Hey Bryan. Is it true that Olivia complained to victims' rights about the name pronunciations? This is a good opportunity for us to try to, again, some of the social media chatter out there, clear up misinformation, do our part as journalists to set the record straight. Have there been any complaints formally, put forth about the name pronunciations by Judge?
Yeah, I don't think it, at least from what I could tell, was a formal complaint, but she did say something when the hearing ended, just sort of in her group, and there was also what appeared to be a victim's advocate there. But I don't think it was so much as a formal complaint as just being sort of frustrated that that the name pronunciation wasn't right.
Let's go to some other comments that are coming in. Allie wants to know, hashtag Hey Bryan, why do you think the Kohbergers didn't show up today? and say, Allie is giving her opinion in the comment as well, saying, I think they want to avoid the media, but it must be hard for Bryan Kohberger not having them supporting him in court. As far as the Kohberger family and communication with them, even in all these months since January when we last saw Bryan in court, I mean, what have we heard, and do we have any understanding as to why they haven't been or why they weren't here today?
Yeah, so they were in court initially in Pennsylvania when he made his first appearance. And it's my understanding, and I haven't had any new information in probably a couple of months. But the last that I had information from that side, it was that they are not in a good financial situation. This is obviously a long way from Pennsylvania, so there would be money involved to get here. So that could be a component. You mentioned, I mean, the media, although they were there in Pennsylvania, and there was probably more media at his first appearance, and they made the decision to be there. So I think it could be a financial issue. I've reported in the past, and I think the situation has also changed. But at one point, his sisters had lost their jobs. And it's obviously not easy being Bryan Kohberger's family right now. So I think all of those things probably contributed.
Bryan Entin of NewsNation joining us here, everybody, on WFLA now. Bryan, just really quickly, I always ask you at the end of our streams, how you holding up? Is life treating you okay? I know a lot of people always follow you for your reporting, but also just because, what they think of you as being a stand-up guy. How you doing out there in Idaho?
Yeah, thanks for asking. Yeah, no, I'm doing okay. It's weird being back. I was just talking to Lauren and Luis, who are out here with me. It's weird being back here, just because we were here for so long, for I think over a month at one point, and it's just weird being back in Moscow, seeing all the same places. It's kind of a sad feeling. The weather is a lot different. It's warmer, which is nice. But again, I don't know. The whole courtroom thing today was really just strange and emotional for the families, and that's kind of what I'm hung up on. Just being in that room, being so close to them and close to Kohberger, all in the same spot. It's just a very, very, you just can't imagine what they must go through, how they're supposed to process that.
I can hear it in your voice, and I can assure you the camera doesn't do it justice as far as how small this courtroom actually was. It definitely, without question, based on what you're saying and your account of it, it definitely looks bigger on camera than it does, I'm sure, with how it felt in that room today, especially when you're talking about it being, jam-packed with people. Bryan, we really appreciate it. Everybody, please give a follow. You probably already do if you're watching this live stream, but please give a follow to NewsNation's Bryan Entin and pass along our best. Bryan, I know that you're with a great team out there from NewsNation. We appreciate you taking the time.
All right, thanks, JB. Have a good day.
Yeah, you as well, Bryan. All right.